Please be seated. Next case or cases are Sims versus Schlott. We've allotted 15 minutes per side total for the two consolidated appeals. Mr. Ledbetter, ready when you are.
Please, the Court. John Ledbetter here for Appellant Paul Sims. To understand this case, the seminal question that has to be addressed is, what did the first DCA do in 2004? Because that's the only way we can understand the subsequent orders resulting in the final judgment that was entered. And as was presented to the trial court below, what your PCA did was determine all issues of liability on every theory for both sets of beneficiaries, and that it was all over except for the question of damages. We, on this appeal, have taken the more limited view, the view that was espoused partially by Mr. Rosenblum, that because the summary judgment was a non-final judgment, because the court had reserved jurisdiction on the question of damages, you did not have jurisdiction to address the merits of the case. So either you did address the merits, it is the law of the case, or you didn't, and all of that is fair game. And I think what is significant is you've got to remember the original theory and the original motion for summary judgment, which was that Mr. Sims had engaged in a series of risky transactions that damaged the trust. By November of 2005, after your appeal, the parties are back in court, and Mr. Sims' attorney at that time is saying, gentlemen, the case is over. All of those monies, all of those 34 questionable transactions that you listed in your motion for summary judgment have been resolved, and the trust has the money or it's in escrow and will be paid. And at that point, the case should have been over. I have trouble understanding the injunction that was entered in 2004, where it says, removes Paul Sims, and it says that we reserve jurisdiction to find out if there are any damages to the trust. It's obvious they were proceeding on the original complaint, which was complaining only about the risky investments. It isn't until 2004, some 4 years later, that the additional group of beneficiaries come and say, we want a jury trial on the issue of breach of fiduciary duty and on self-dealing. And somehow that has been interpreted, and I have not seen any orders, any pleadings where both sets of beneficiaries adopt each other's pleadings and are treated as one by the court, but that's exactly what happened. That was the result of the court's interpretation and the version of what your PCA meant to the trial court. And that's when the trial court said, well, it's all over, it's the law of the case. Every theory for both beneficiaries has been decided. And another important distinction is, on addressing the propriety of that, the motion for summary judgment, is the beneficiaries stand in different positions. The second group was actually, some of them were also named as co-trustees and were alleged to have breached their fiduciary duty, which brings up the obvious question, at least as to those beneficiaries, the issue of waiver, consent, acceptance. It was over 4 years while this litigation was going on, and they knew of all the complaints being made by the first two sets, or the first two women that were complaining about the trust, that these were risky investments. They accepted the benefits. They knew that Paul Sims had made money for the trust and was continuing to make money for the trust, and it wasn't until 4 years later that they jumped ship and jumped on the bandwagon. But none of those pleadings, either the initial one or the second one, set out a claim for constructive trust or tracing of assets. It wasn't pled, it wasn't asked for. So we have to look at that initial injunction that was granted. The only way to read that is this court said the scope's okay, the procedural issues are all right, and we're reserving jurisdiction as to the propriety or as to the actual merits. And as we suggest in the brief, there's a number of grounds of factual issues that were argued at the hearing that Swanson overruled them, but that we've set forth in the brief, that these, if it was self-dealing, it was structured so to protect the trust. And if, in fact, there was self-dealing, it was authorized by the settler, Mattie Kelly, who had been married to Mr. Sims and divorced, and he came back at her request to manage the trust and make money for it, which he did. Everyone agrees. Also that he's a non-professional trustee. He's entitled to rely on the advice of counsel. All of this was done above board in open public records on the advice of professional counsel that he retained, that he could structure this that way. He's never been allowed to present that or any other arguments to a jury. And the jury trial was demanded by the second group on their claim for breach of fiduciary duty and self-dealing. We've never had that issue.
But how is that question not resolved by the per curiam affirmance of the previous order? Seems to me it's implicitly resolved by that order. The order was an order removing Mr. Sims as a trustee. Didn't the court necessarily pass on the breach of duty that was underlying that whole claim?
The court found that there was at least the appearance of a breach of fiduciary duty. They granted the motion for summary judgment as to the fact that those were risky investments. That was the theory pled, and that was the theory argued at the motion for summary judgment. We know now that that theory was completely wrong, that the trust got all of that money, made their 10% return, as Mattie and Kelly had instructed Paul Sims to do. So that issue was moot. That injunction should have gone away at that point at the hearing where they moved to dissolve it in May. And that's when we get the new theory.
Well, you concede, I guess, that a per curiam affirmance can operate as the law of the case.
Well, certainly.
And that the decision of the court, whether it's per curiam without opinion or with an opinion, extends to questions not only actually presented to the court, but those that are implied by the decision.
If the court had jurisdiction to reach the merits of the case, and I'm suggesting to you that only you know, you were on the panel, Judge, and I certainly do.
Well, we don't affirm cases when we don't have jurisdiction.
Well, you did have,
for lack of jurisdiction.
You did have, what I'm suggesting is you did have jurisdiction to review the injunction, its scope, and whether it was proper in the procedural steps that have to be taken.
Well, this was a summary judgment, wasn't it?
It was a motion for summary judgment, but the court reserved jurisdiction to determine damages. The argument was made that you can't reach the merits of that, Judge. All you can address is the scope of the injunction itself. And that was a large part of Mr. Rosenblum's argument. And, in fact, that was the question. I reviewed the video. That was the question you directed to him. Would you address the question of whether we even have jurisdiction to consider the merits of the summary judgment? Or are we limited to the injunction? And that was the question you asked, and I would suggest to you that that's what the court did. Nevertheless, Mr. Sims has not had his day in court. As you know, there was an order striking his pleadings after a fourth amended, or I believe this was the fourth set of interrogatories and discovery, addressed to certain set-offs and expenses that Mr. Sims was claiming that he didn't make $6 million on these deals, that it was less. They asked for details. They weren't forthcoming. They had a hearing. He said, you're going to give them to him in 10 days or I'm going to strike your pleadings. Came back 10 days later, even though Mr. Sims had complied, even though we supplied affidavits that he met with his secretary, he met with his CPA. Together, they faxed and answered everything to the best of their ability. They gave everything they had. Now, because the order said full and complete, the plaintiffs complained. The judge, who had already made up his mind on the issue some 10 days before, when he said, if you don't do it, I'm going to strike them, struck them. And it wasn't a narrowly crafted sanction. It was punitive. It essentially, the way it was interpreted later, ended the case. Now, as you know, when we got a copy of the transcript of the comments that Judge Bell made during that hearing, we asked him to recuse himself, which he promptly did. We then asked for reconsideration of the motion striking the pleadings. We attached our affidavits. We asked the court to look at the responses and whether or not this is a transgression worthy of the ultimate sanction. But it, again, was rubber stamped. Nobody wanted to go back and replow the ground that had already been done. You got to remember, we had umpteen judges on this. It seemed like every significant hearing we were coming back before a new judge.
Well, that's because you all moved to recuse several.
Only the one. But, no, I understand the court's point. So, and because I'm running out of time, let me just briefly address the civil contempt issue. Judge, he was found in contempt, as you know from reading the briefs. But it's axiomatic. You've got to have a clear, unambiguous order before you can be found in contempt of court. Why was it ambiguous? Because the version that was presented by plaintiffs, which you can't write a single check, you can't do anything with any of your money under the terms of that injunction without court approval. But the court themselves said, I don't care he's paying his bills or whatever. That's not what that means. How is he to know he is not allowed to make any further investments? More importantly, the source of the funds that were transferred were never identified. We don't know whether they came from Mr. Sims individually. We don't know whether they came from business deals that he had with other entities that weren't related to the trust. We don't know that. Significantly, he was never given a chance. They never had a rehearing on the purge. Well, actually, first, the funds that were to be used for the purge were never identified in the order, as is required. And moreover, he was given a week to comply and purge or report to jail. And when he reported back, he was incarcerated. They never had another hearing, as they're required to, on whether Mr. Sims still had the ability to purge at that time. So, as a result, an 87-year-old man is thrown in jail, and finally, by executing a joint stipulation, he is allowed out. But that order was improper, and for all of those reasons, and shouldn't have been issued. Judge, I've only got 2.5. I'm going to reserve the rest of my time.
Okay. Mr. Rosenblum.
May it please the court, Louis Rosenblum for the appellees. It was quite a while before I was able to determine which issues counsel was arguing, but I think he argued the first issue, law of the case, second issue, the order striking pleadings, and the third issue, the contempt. Let me take, with the court's permission, let me take those in reverse order, and let me explain to the court, probably what it already knows from the briefs, why Mr. Sims was held in contempt. First of all, there's nothing ambiguous about the scope of the injunction. In 2005, Mr. Baranek stood right before this court and complained that it was too broad. He said words to the effect that Mr. Sims can't even go to the grocery store and write a check without court approval. Well, whether that's true or not, that's what he argued then, and the court affirmed it. Now, the record shows that this injunction is broad, and for that reason, counsel for the appellees on several occasions, and this is in the record at court hearings, said, please, Mr. Sims, give us a budget, and we'll let you spend whatever you need for your personal needs, and we won't complain about that. But he never complied. So what he ended up doing, and let me first talk about the theory that the injunction only applied to his business, not to his personal assets. The injunction prohibits him from spending or hypothecating, transferring, pledging, etc., any asset owned by Sims individually. Number two, any asset owned by SC of Okaloosa, and that's his solely owned subsidiary company. And three, any other business entity that gets any benefit indirectly or directly from a trust asset. That last language, the indirectly or directly, only talks about businesses other than SCO and Mr. Sims. So it's pretty broad. There's no doubt about that. So what did Mr. Sims do? He conspired, I don't know what other word I can use, with a gentleman from Miami, a Mr. Ravallo, that he admitted he hardly knew. And here was his scheme. He took $1.5 million and transferred it to Mr. Ravallo. And for the purpose, Mr. Ravallo was going to get him set up with a residence in Dade County so he could file a bankruptcy petition in the Southern District of Florida using Ravallo's lawyers for the purpose of, one, getting around the injunction in Okaloosa County, and two, stopping the litigation. And he admitted to this under oath. He admitted it at the bankruptcy hearing, which, by the way, once he'd testified, his lawyers dismissed the petition because they obviously knew they were in trouble. But he filed a third-party complaint against Mr. Ravallo, and he admitted this whole plan and his duplicity in it. So what is the court supposed to do when you have a man who not only violates the injunction, and of course this was just $1.5 million. There was another $1.5 million that he had spent in violation of the injunction. But the $1.5 million to Mr. Ravallo was pretty outlandish. So the judge found from the evidence that if he could come up with $1.5 million to Ravallo, maybe he could get it back and purge himself of the contempt. So he found that he had the present ability to pay. And if you read the contempt order, all of the I's are dotted, all the T's are crossed. There's absolutely no abuse of discretion or any error. I'm not familiar with any second or third purge hearings you get on an indirect civil contempt. You're required to give notice, and that was given. You were entitled to give an opportunity to be heard, and he was heard. He came to court and testified, and an opportunity for purge, and he was given that. And as far as I'm concerned, that ends the inquiry with that. Now, let's go to the order striking the pleadings. It was not just the last one occasion. And if you, this case has been pending. Now, Mr. Ledbetter, in all due respect, he didn't come into the case until 2007. The case had been pending for 7 years. A lot had gone on before he arrived. But we do know, and I'm just summarizing, that in 2004 he didn't answer the interrogatories. Even the summary judgment this court affirmed directed him to answer interrogatories. We're still waiting for the answers for those. He twice failed to appear at depositions. He failed to answer interrogatories in 2005. He failed to respond to a request for production in 2006. There was additional discovery he failed to answer in 2006. He failed to respond to discovery in 2007. There were at least 10 motions in this case to compel discovery. And almost all of them, Mr. Sims was represented by one lawyer or the other. And each time he changed lawyers, the judge cautioned him that this was not an excuse. It was not going to be excused for failing to comply with court orders. Now, the straw that broke the camel's back was when the beneficiaries filed a motion for summary judgment on damages. They had traced net profits that Mr. Sims had taken for his own benefit that belonged to the trust of $6,086,907.22. And in the motion, they gave him credit for the cost of the land, the development costs, the interest and carrying charges, and the usual things that would come off the gross sales. And they came up with that figure, and Mr. Sims filed an affidavit in response and said, oh no, I'm entitled to a lot more offsets than that. So the beneficiary sent him discovery. Request for production, show us your documents. Interrogatories, tell us what your offsets are. Lo and behold, he answered the interrogatories and he said, I get offsets based on my figures of $6,086,907. Missed by 22 cents of saying exactly what the claim was. I mean, already you know that this is a sham. he produced some documents that didn't support his offsets. These were documents that were matter of public record, deeds and mortgages, or documents that he had produced in the bankruptcy court that we already had. So the beneficiaries filed a motion after that to strike the pleadings. And there was already an order compelling discovery that said if you don't give complete and full answers, I'm going to strike your pleadings. These were not complete. They were not full. There was another hearing held, and Mr. Sims didn't show up, and neither did his counsel. So the court properly struck his pleadings and precluded him from presenting any evidence. He had ample due process. Again, just like the contempt order, all the I's were dotted, all the T's were crossed. Now, the law of the case argument. Yes, I did argue in the first appeal that the court did not have jurisdiction to entertain the summary judgment. But that wasn't the first argument I lost in the court, and probably won't be the last. I was wrong. The court disagreed with me. As you said, the court doesn't issue rulings on the merits when it doesn't have jurisdiction. So the PCA affirmed the summary judgment order. And what's included in that order? First of all, I heard Mr. Ledbetter 2 or 3 times saying, well, he was removed trustee because of risky investments. These were not risky investments. These were self-dealing transactions. Mr. Sims was using the trust as his bank. And what he would do is he would have a real estate, and by the way, the trusts were authorized to deal in real estate and to do development. But what Mr. Sims did is when he found a good real estate deal, he would borrow the money personally from the trust, give him a note for 10%, he thinks was fine, and then he would make a fortune off the deals and repay the loan, and he would keep the profits for himself. I'll give you a case in point. There was a deal in the record called Deerland Development, where the contract to buy the land was executed by the trust. And at closing, Mr. Sims shifted the contracting party from the trust to this SC of Okaloosa County. And he borrowed, Sims did, $2.6 million from the trust. He eventually paid him back $260,000, but he made $2.2 million off the deal that should have been the trust money. That's what he did. It was not risky investments. It was self-dealing, which is absolutely prohibited. There's a statute, and this came up in the first appeal, there's a statute that says if you do any self-dealing transactions, you have to get approval from the court, and of course he never did. So he was not removed for risky investments. The trial court says in summary judgment that he had violated his fiduciary duty on numerous occasions, and they list the different transactions, and also said he was using trust assets for the furtherance of his own personal gain, either directly or indirectly through his wholly owned and controlled company, SC of Okaloosa. And in the end of the order, the court left only the issue of damages, and that was the only issue left after the summary judgment. Everything else Mr. Ledbetter has talked about in his brief has been argued either by Mr. Baranek in his briefs or in the summary judgment proceedings below. It's all been decided by the law of the case. Now, Mr. Ledbetter has said in his brief, well, they got the 10% back, so the trust is whole, but that's not so. There are two losses, two elements of our loss that the trust has here. First of all, at the time that Mr. Sims was removed, there were millions of dollars in outstanding loans that Sims had made from the trust to himself that had not been repaid. The successor trustees, and the record will show they, with commendable effort, went all over the country chasing this money. I mean, numerous different states, numerous different venues, and eventually recovered all of the money, or most of the money, including the 10% interest. But that left all of the damages that Mr. Sims pocketed himself. Over $6 million of self-dealing transactions where he put the money in his pocket instead of in the trust. So once the successor trustees got the loans back through foreclosures and whatever else they did, that didn't end the case by any means. So the only issue left was damages. That's been determined at $6 million. All of this, every bit of it is law of the case. If you look at Mr. Ledbetter's reply brief, he's got a list. He's got a list of things that he says, that are still unresolved, and they've all been resolved. And I just want to give the court, I only have a couple of minutes, I just want to give the court an example. He said, he says that Mrs. Kelly authorized him to self-deal in the trust. Well, that's exactly what he argued at page 27 of his brief in the first appeal, but then the trust agreement says that all powers given to the trustee by this trust are exercisable by the trustee only in fiduciary capacity. I mean, these contentions just aren't so. One other example, the trust authorized Sims to receive reasonable compensation, and that the monies he received constituted reasonable compensation. So he's saying that $6 million in profits that he garnered were reasonable compensation, and I respectfully differ with that. In fact, the record shows that he received over the years in real compensation over $1 million. So to say he gets an extra $6 by borrowing money from the corporation, the trust for his own account is more compensation than he deserves is just not so. And, you know, the bottom line in this case is Mr. Sims was afforded every possible due process. He had good lawyers all the way throughout. I mean, he fired most of them, but he had some of the best firms in Northwest Florida. He had firms from South Florida, and the judgment that's before this court was entered with full due process, and it should be affirmed. Thank you.
Mr. Ledbetter.
Just addressing his last point first. Claims there's $6 million in damages. How do we know that's what happened? We don't have a verified pleading. We don't have a certified audit. These are numbers put together by plaintiffs' attorneys that have yet to be exposed to the crucible of cross-examination, the crucible of truth. We don't know what those numbers are. That's their allegation that he made the money, but we've never had a hearing on the merits. Mr. Sims, despite 9 years, has never had a trial. We can't even address the issue of damages. If you'll remember what the trial court's ruling was, is that, we can have a trial, but you're not allowed to challenge anything introduced into evidence. You can't cross-examine, even if the person who compiled these numbers is employed by the trust. You can't get into bias. You can't look at these numbers at all. You just have to accept them.
That was what, Mr. Ledbetter?
The reason was the pleadings were improperly stricken. You know, and that wasn't, when the judge entered that, the motion striking pleadings, Judge, look back at the contempt order some 5 months, year and a half before that, a year and a half before. What was the sanction if Mr. Sims did not report to jail? They were going to strike his pleadings. This is language that they have inserted over and over again, even though the situation has never been analyzed if that's an appropriate sanction. It's just thrown out there every time.
Was there a hearing held on that?
On what? The motion to strike?
On whether the striking the pleadings was...
Yeah, there was a hearing. And the judge recused himself once we got a transcript, and he said, no, I'm out. And properly, we moved for the subsequent judge to reconsider that and to look at the things we said, which is we've answered. They didn't like the answer they got.
You actually had a hearing on that before the successor judge. You made all your arguments, and the successor judge refused to vacate the prior order.
We never had an evidentiary hearing.
Did you ask for an evidentiary hearing?
We never had an evidentiary hearing.
You asked for an evidentiary hearing.
Yes, we did. We presented affidavits, and we asked to have a hearing on the merits of whether or not this was an appropriate sanction. The judge said, I'm going to rubber stamp that order. I'm sorry.
No, go ahead.
I guess I'm over. I see the red. Anyway, we just ask the court to please remand this, clarify the pleadings, and give Mr. Sims his day in court. Thank you.
Thank you.
Thank you both, gentlemen.